While the mainstream media floods your feed with celebrity gossip and political theater, something massive just happened in one of America's most influential courts, and there's a reason you haven't heard about it. The Fifth Circuit Court of Appeals just dismantled 8 concealed carry restrictions in a single month. We're not talking about small technical adjustments, we're talking about rules that gun owners have been living under for decades, gone in one decision. And the silence from major news outlets, that tells you everything you need to know about who controls the narrative. Right now, over 75% of people watching content like this aren't subscribed. If you actually care about knowing your Second Amendment rights before you need them, hit that subscribe button and turn on notifications. Because what I'm about to break down could be the difference between carrying legally and confidently, or walking into a situation thinking you're breaking the law when you're actually not. The case framework comes from United States versus Rahimi, but what happened in March was a follow-up decision that took that framework and applied it like a sledgehammer to 8 specific restrictions. We're talking about rules that sheriffs, police chiefs, and licensing authorities have relied on to deny permits, restrict where you can carry, and make exercising your Second Amendment right as complicated as possible. This was a 3-judge panel that looked at the historical record, applied the standard from New York State Rifle and Pistol Association versus Bruin, and concluded that most of what states have been doing doesn't pass constitutional muster. Here's why this matters more than you think. After Bruin dropped in 2022, the entire legal landscape shifted. The Supreme Court said courts can't just use interest balancing anymore. You can't say, well, this restriction seems reasonable and it might make people safer, so we'll allow it. That approach is gone. Now, if the government wants to restrict your Second Amendment rights, they have to prove the restriction is consistent with America's historical tradition of firearms regulation. That means looking back at laws from the founding era, the Reconstruction era, and showing that what they're doing now actually fits with what the framers understood. That's a massive shift. It's like the entire game changed at halftime, and now every gun law in the country has to prove it belongs on the field. The Fifth Circuit took that standard seriously and applied it to restrictions that have been flying under the radar for years. And when they couldn't find historical justification, they struck them down. No hesitation, no compromise. Let me walk you through what actually got crushed, because this is where it gets real. First, subjective denial standards. This is the rule where a sheriff or police chief can look at your application and just decide they don't like you. Maybe they think you don't have a good enough reason to carry. Maybe they don't like your attitude. Maybe you didn't donate to their re-election campaign. Whatever the reason, they can deny your permit based on nothing more than personal judgment. The Fifth Circuit said that's unconstitutional. If the government is going to stop you from exercising a fundamental right, they need an objective, law-based reason, not a gut feeling, not a vibe check. Think about it this way. Imagine if your right to vote depended on convincing a single government official that you were responsible enough to cast a ballot. Imagine if they could just say no because they didn't think you demonstrated sufficient need to participate in democracy. You'd lose your mind, right? That's exactly what's been happening with concealed carry permits in some jurisdictions. One person gets to decide if you're worthy. The Fifth Circuit looked at that and said it doesn't fly. If you're not a prohibited person, if you haven't committed a disqualifying crime, the government can't arbitrarily deny you based on subjective standards. Second, blanket bans on carrying in all government buildings. Now, this requires nuance because people are going to misunderstand it. The court didn't say you can walk into a courtroom or a legislative session with a firearm tomorrow. What they said is that the government can't just declare every single building with a government employee inside to be a gun-free zone without historical justification. The rule that says you can't carry in the DMV, the post office, the county clerk's office, any place with a government function, that's too broad. For over 50 years, the federal government has treated the local post office like a high-security bunker. If you even had a firearm in your car in the parking lot while mailing a letter, you were technically a federal felon. The court looked at the history of the Postal Service and found that in 1791, and for nearly 200 years after, there was zero tradition of disarming citizens at the post office. Back then, the post office was often the only place to get news and stay connected. It was a public hub, not a sensitive zone. The court said the government can protect genuinely sensitive places. Courtrooms where trials are happening, legislative chambers when they're in session, places where there's a specific, historically recognized need for heightened security. But they can't just say every government building is off limits because it's convenient. If the founders didn't ban firearms in government buildings in 1791, and there's no tradition of doing so, you need a compelling reason to do it now. And we think it's safer isn't good enough under Bruin. Third, mandatory live fire training requirements. Some states require you to take a class, pass a written test, and demonstrate shooting proficiency before they'll issue you a concealed carry permit. On the surface, that sounds reasonable. We want people to know how to handle firearms safely. But the Fifth Circuit said there's no historical tradition of requiring citizens to prove competence before exercising a constitutional right. You don't have to pass a test before you can speak in public. You don't have to demonstrate knowledge of theology before you can practice your religion. You don't have to prove you're a good writer before you can publish an article. The right comes first. The government can encourage training. They can offer it. They can incentivize it. But they can't make it a mandatory barrier to entry. That's prior restraint on a constitutional right. Let me be crystal clear about something. This doesn't mean training is bad. You should absolutely know how to use your firearm safely and effectively. You should seek out instruction. You should practice. But that's your responsibility as a gun owner, not a legal requirement the government can impose before you're allowed to carry. There's a difference between something being a good idea and something being constitutionally mandated. Fourth, prohibitions on carrying in places of worship. This one surprises people. Some states had laws that said you couldn't bring a firearm into a church, synagogue, mosque, or any other place of worship unless you had explicit written permission from the religious leader. The Fifth Circuit looked at the historical record and said that's not supported by tradition. In fact, colonial Americans routinely brought firearms to church because religious services were often the only time entire communities gathered in one place. Churches were community centers. And in frontier areas, they were sometimes the only defensible structures around. Banning guns in places of worship is a modern invention. It doesn't have roots in American legal tradition, so under Bruin, it fails. Now here's the key distinction. Private property owners, including churches, can still set their own rules. If your church has a policy against firearms, you need to respect that. This ruling doesn't override private property rights. What it does is prevent the state from criminalizing carry in religious spaces across the board. Fifth, bans on carrying in any establishment that serves alcohol. This one gets confused all the time, so pay attention. Some states didn't just ban carrying while intoxicated, they banned carrying in any place that has a liquor license, period. That means if you walked into a restaurant that has a bar, even if you're just there for lunch and you're completely sober, you could be arrested just for being on the premises while armed. The Fifth Circuit said that's too broad. They pointed out that taverns in the 1700s and 1800s were central gathering places. People conducted business there. They ate there. They socialized there. And there's no historical evidence of blanket bans on carrying firearms in such establishments. The government can absolutely prohibit carrying while intoxicated. That's a legitimate safety concern with historical backing. But they can't prohibit carrying near alcohol entirely just because alcohol is present. Under this ruling, you can walk into a restaurant with a bar, sit down, order food, and carry your firearm as long as you're sober. The moment you drink, the rules change. But proximity to alcohol alone isn't enough to strip you of your rights. Sixth, residency requirements for permits. Some states said you had to live in the state for 3 months, 6 months, even a year before you could apply for a concealed carry permit. The idea was that they wanted to make sure you were a stable resident before granting you the privilege, but the Fifth Circuit said rights don't work that way. If you're a legal resident of a state, you have the same Second Amendment protections as someone who's been there for 20 years. You can't delay a constitutional right based on how long you've been paying state taxes. This is huge for people who move frequently, military families, people who split time between states for work. Under the old rules, you'd establish residency, get your driver's license, register to vote, and then have to wait months before you could even apply to carry. That waiting period is now unconstitutional. If you're a resident, you can apply immediately. Seventh, magazine capacity restrictions specifically for concealed carriers. A few jurisdictions tried to thread a needle. They said, okay, you can have a concealed carry permit, but if you carry, you can only use a firearm with a 10-round magazine, or 7 rounds, or whatever arbitrary number they picked. The Fifth Circuit said that doesn't work. If the firearm is legal to own, and you have the right to carry it, the government can't impose additional restrictions on how you carry it that don't apply to everyone else. Magazine capacity limits are a separate legal question, but you can't single out concealed carriers and treat them differently. Either the magazine is legal or it isn't. You can't create a special subclass of carriers who get less protection than everyone else. Eighth, vague, good moral character requirements. Some permit applications include a question asking if you're of good moral character. Sounds innocent, right? The problem is nobody defines what that means. So you could get denied because you got into a bar fight 15 years ago, or because you had a messy divorce and your ex wrote a nasty letter about you, or because the reviewing officer just doesn't like your answers on the application. The Fifth Circuit said that's way too subjective. If the government wants to deny your Second Amendment rights, they have to point to specific, objective disqualifying conduct. Felony convictions, domestic violence convictions, adjudicated mental health issues, things that are defined by law and provable in court. They can't just say you lack good moral character based on vibes. Here's what this means for you right now, today. If you live in Texas, Louisiana, or Mississippi, these 8 restrictions are gone. They're not enforceable anymore in the Fifth Circuit. If you were denied a permit under one of these rules, you have grounds to challenge that denial. If you've been avoiding carrying in certain places because you thought it was illegal, you need to reassess. The legal landscape just shifted under your feet. But even if you don't live in the Fifth Circuit, this ruling matters. Court decisions in one circuit influence others. Lawyers in California, New York, Illinois, they're already citing this case in their briefs. Judges in other states are reading it and thinking about how the reasoning applies to their cases. And if this case gets appealed to the Supreme Court and the court agrees to hear it, this could become the law of the entire country. We're watching a ripple effect happen in real time. Every restrictive gun law is now under scrutiny. Courts are being forced to do something they haven't had to do in decades, actually prove that restrictions are constitutional instead of just assuming they are. Let me give you 3 realistic scenarios so you understand how this affects your daily life. Scenario 1. You live in Texas. Last year, you applied for a license to carry, and the sheriff denied it because he said you didn't demonstrate sufficient need. You weren't a prohibited person. You had no criminal record, but the sheriff just didn't think you needed to carry, so he said no. You appealed through the administrative process and got nowhere. Under this new ruling, that denial is unconstitutional. Subjective need-based denials are gone. You can refile your application or challenge the previous denial in federal court, and you've got Fifth Circuit precedent backing you up. Before this ruling, you were out of luck. Now you have a legitimate path forward. Scenario 2. You're a Louisiana resident, and you've been carrying for years. You attend church regularly, and you'd like to carry when you go because services are early in the morning and you drive through some rough areas to get there. But Louisiana had a law that said you couldn't carry in a place of worship without written permission from the religious leader. You never asked your pastor because you didn't want to create controversy. Under this ruling, that state law is likely unenforceable. Now, you still need to be smart about this. If your church has a private policy against firearms, you need to respect that. Private property owners can set their own rules. But the state can't criminalize it anymore. The government restriction is gone. Private restrictions still apply, but you're no longer facing potential criminal charges just for being armed in a house of worship. Scenario 3. You're planning to move from Mississippi to Texas for a new job. You want to get your license to carry as soon as possible because you'll be working late nights and driving through unfamiliar areas. But Texas has a 6-month residency requirement before you can apply for a license to carry. Under the old system, you'd have to wait half a year after moving before you could even submit an application. Under this ruling, that residency requirement is unconstitutional. You should be able to apply as soon as you establish legal residency in Texas, which typically just means getting a Texas driver's license and having a lease or proof of address. If the state tries to deny you based on the residency timeline, you can point to this Fifth Circuit decision and challenge it. But here's the critical part that most people miss. Just because a restriction was struck down by the Fifth Circuit doesn't mean every sheriff's office and police department knows about it yet. Some agencies are still operating under the old rules because they haven't updated their policies or trained their staff. If you get denied under one of these unconstitutional restrictions, or worse, if you get arrested, you need to know your rights and be ready to fight. That means having the contact information for a lawyer who specializes in Second Amendment law. It means documenting everything, saving emails, keeping copies of applications and denials, and it means staying calm and not escalating the situation even if you know you're right. The law is on your side now, but you still have to navigate the bureaucracy carefully. Let's clear up some dangerous myths and misconceptions because confusion is already spreading. Myth number 1. This ruling means you can carry anywhere without a permit. Absolutely false. This decision struck down certain restrictions on permits and certain restrictions on where you can carry if you have a permit, but it did not eliminate permit requirements in states that have them. If your state requires a license to carry concealed, you still need to get that license. What changed is how much arbitrary power the state has to deny your application and what restrictions they can attach to your permit. Myth number 2. You can carry while drinking now. Wrong. The ruling addressed bans on carrying in places that serve alcohol. It did not address laws against carrying while intoxicated. Every state still has laws prohibiting carrying a firearm while under the influence of alcohol or drugs. Those laws are still fully in effect. What changed is that you can now enter a restaurant that happens to have a bar and carry your firearm as long as you remain sober. You can sit down, order food, have a conversation, and not worry about criminal charges just because there's a liquor license on the wall. But the second you consume alcohol, the rules change. Know the difference. It could save you from a felony conviction. Myth number 3, this only matters if you live in Texas, Louisiana, or Mississippi. Not even close. Yes, the Fifth Circuit's jurisdiction only covers those 3 states, but court decisions don't exist in a vacuum. This ruling is already being cited by lawyers everywhere. Judges in other states are reading this opinion and considering how the reasoning applies to their cases. And if this case gets appealed to the Supreme Court and the court takes it, the ruling could become binding on the entire country. Even if you live outside the Fifth Circuit, this decision is shaping the future of gun rights nationwide. It's influencing how other courts think about these issues. It's giving lawyers ammunition for challenges in their own jurisdictions. Here's what most people are missing about the bigger picture. This isn't just about concealed carry. This is about how courts evaluate all gun laws going forward. Every restriction, from waiting periods to feature bans to licensing schemes to magazine limits, now has to meet the Bruin standard. And that standard is unforgiving. The government can't just say a law is reasonable or that it serves a good purpose. They have to prove the restriction is consistent with America's historical tradition of firearm regulation. That's a high bar. And a lot of laws that have been on the books for decades aren't going to clear it. We're watching a transformation happen in real time. For years, courts gave the government the benefit of the doubt on gun laws. If something sounded sensible, it usually survived judicial review. But Bruin flipped that presumption. Now the government has to prove its case with historical evidence. And when they can't find that evidence, which is often the law fails, let's talk about what happens next, because this story is far from over. First, expect appeals. States aren't going to take this lying down. They're going to ask for an en banc review, which means the full Fifth Circuit, all the judges, would rehear the case instead of just the 3-judge panel. That process takes months, sometimes over a year. They might also try to appeal directly to the Supreme Court, although the court doesn't have to take the case. Second, other states are going to try to rewrite their laws. They'll look at what got struck down and try to craft new restrictions that they think will pass the Bruin test. They'll dig through historical records looking for any precedent they can find. Some of those efforts might succeed. Most of them probably won't, because the standard is tough. Third, gun rights organizations are going to use this decision as a template. Groups like the Second Amendment Foundation and the Firearms Policy Coalition are going to file lawsuits in other circuits using this ruling as their foundation. We're going to see challenges to similar restrictions in the Ninth Circuit, the Second Circuit, the Fourth Circuit, all the places where gun rights have been most restricted. Some of those circuits are going to rule differently. The Ninth Circuit, which covers California, is notoriously hostile to gun rights. They might uphold restrictions that the Fifth Circuit struck down. And that's actually good for gun owners in the long run, because when circuits disagree, it creates what's called a circuit split. And when there's a circuit split on an important constitutional question, the Supreme Court is much more likely to step in and resolve the issue for the entire country. Drop a comment and tell me which state you think is going to fight this the hardest. And if you're finding this breakdown valuable, subscribe right now so you don't miss what happens next. These legal battles move fast, and you need to stay ahead of the curve. The Fifth Circuit struck down 8 concealed carry restrictions in March, and the impact is going to reverberate for years. Subjective permit denials, blanket government building bans, mandatory training requirements, prohibitions on carrying in places of worship, bans on carrying near alcohol, residency requirements, magazine restrictions for carriers, vague moral character tests, all of them gone in the Fifth Circuit, and it happened because judges finally took the Constitution seriously and demanded that the government justify its restrictions with history and tradition, not just good intentions and political preferences. Here's what you need to remember. First, know your rights. If you live in Texas, Louisiana, or Mississippi, these changes apply to you right now. If you live anywhere else, they might apply soon, and you need to be ready. Second, don't assume local authorities are up to date on this ruling. Some are, some aren't. If you encounter resistance, be respectful but firm, and get legal help if necessary. Third, this is just the beginning. More cases are coming. More restrictions are going to be challenged. More circuits are going to weigh in. And the more we stay informed and engaged, the stronger our rights become. The ability to defend yourself and your family is fundamental. It's not a privilege the government grants when they feel like it. It's a right you already have. And every time a court strikes down an unconstitutional restriction, that right becomes a little more real and a little more protected. If you made it this far, you're serious about understanding your rights. Subscribe and turn on all notifications. Legal developments are dropping constantly, and you need to stay ahead of them. Drop a comment and tell me which restriction you're most glad to see gone. Stay armed, stay legal, and stay informed.